Indian Contract Act 1872 Simplified Explanation 1. What is the Indian Contract Act 1872? The Indian Contract Act was passed in 1872 and became effective on September 1st, 1872. It is the main law that governs contracts in India. Contracts equals legal agreements that bind parties to fulfill their promises, based on English common law, which comes from past court decisions. 2. What does the Indian Contract Act cover? Initially, the Act had 66 sections in 11 chapters, but now it mainly covers General Contract Rules, Sections 1 to 75, Basic Contract Laws and Quasi-Contracts. Special Contracts, some specific types of contracts. Indemnity and Guarantee, Sections 124 to 147, protecting someone from loss. Bailment and Pledge, Sections 148 to 181, temporary transfer of goods. Agency, Sections 182 to 238, one person acting on behalf of another. Sale of Goods, 1930, and Partnership, 1932 laws were removed from this act and became separate laws. 3. Key points to remember. The Indian Contract Act 1872 equals contract law in India. Legally binding promises. When both parties agree, they must follow through. Special contracts, indemnity, bailment, pledge, and agency. Sale of goods and partnership are now separate laws. Example for easy understanding. Imagine you order a pizza online. The restaurant promises to deliver, and you promise to pay. This is a contract. If they don't deliver, you can take legal action, and if you don't pay, they can take action against you. 5. Trick to remember. Trick word, I, indemnity. S, special contracts. P, pledge and partnership, removed in 1930. 1932, agency. This helps recall key topics in the Act. Aims and objectives of the Indian Contract Act, 1872, simplified. 1. Why was the Indian Contract Act created? The law exists to make sure that people keep their promises in a contract. If one party fails, the other party has the right to take legal action. Defaulters, rule breakers, are forced to fulfill their commitments. 2. Key points to remember. Contracts, agreements that must be followed legally. If one side fails, the other gets legal protection. Law ensures fairness in business deals. 3. Example for easy understanding. Imagine you book a cab online. You promise to pay, and the cab driver promises to take you to your destination. If the driver doesn't show up, you can complain to the company. If you don't pay, the driver can take action. The Indian Contract Act ensures both sides follow the agreement. Trick to remember. Promises must be honored. Promises of the aggrieved party obligations are enforced legally. This will help recall the purpose of the Act. Application of the Indian Contract Act 1872 simplified. 1. Where and how does this law apply? The Indian Contract Act 1872 became effective on September 1st, 1872. It applies to all of India except Jammu and Kashmir. Not a complete law, it covers general contract rules but not all contracts. Separate laws exist for specific contracts like negotiable instruments, checks, promissory notes, etc. Transfer of property, sale of goods. Partnership. Insurance. Customs and trade practices are not affected. If businesses follow a specific custom, the law respects it. 2. Example for easy understanding. Sale of Goods Act. If a shopkeeper sells a defective mobile phone, this act protects buyers. Transfer of Property Act. When buying a house, rules are different from a regular contract. Negotiable Instruments Act. If a check bounces, this law applies instead of the Indian Contract Act. 3. Key points to remember. Effective 1st September 1872. Covers general contracts, but not all contract types. Special contracts have separate laws. Trade customs are respected. 4. Trick to remember. Trick word, PINST. Partnership Act. I. Insurance Act. Negotiable Instruments Act. Sale of Goods Act. Transfer of Property Act. This will help you recall what's not covered under the Indian Contract Act. Important definitions under the Indian Contract Act, 1872 simplified. 1. Proposal, offer. When one person expresses that they are willing to do or not do something, expecting approval from the other person. Example, a shopkeeper says, "I will sell you this laptop for $50,000. This is a proposal. 2. Promise. When the other person accepts the proposal, it becomes a promise. Example, you say, "Yes, I will buy the laptop for $50,000. Now it is a promise. 3. Offeror and offeree, promiser and promisee. The person who makes an offer equals offeror, promisor. The person who receives the offer, offeree, promisee. Example, the seller, offeror, offers to sell a car. The buyer, offeree, accepts the offer. 4. Consideration. Something given in return for a promise can be money, goods, services, etc. Example, you promise to pay $10,000 per month for rent. The landlord lets you stay in the house. 10,000 equals consideration for the promise. 5. Agreement. Every promise, consideration equals agreement. Example, you agree to paint a house for $20,000. Painting equals your promise. 20,000 is consideration. Has 6. Reciprocal promises section, when both sides have to fulfill promises to each other. Example, a pizza shop promises to deliver pizza and you promise to pay $500. Both are giving something in return, so it's a reciprocal promise. 7. Void agreement, section 2. An agreement that cannot be enforced by law. Example, a contract for illegal activities, like selling banned drugs, is void. 8. Contract, section 2H. Agreement plus legal enforceability equals contract. Example, a builder agrees to construct a house for 50 lakh. The agreement is enforceable in court, so it is a contract. 9. Voidable contract, section 2I. A contract that is legally enforceable by one party but not the other. Example, a contract with a minor under 18 can be canceled by the minor but not by the other party. 10. Void contract, section 2. A contract that was once valid but later becomes unenforceable. Example, you signed a contract to rent a shop, but a new government rule bans commercial activities there. The contract becomes void. Key points to remember: proposal, promise, agreement, contract, consideration, something in return for a promise. Some contracts are void or voidable depending on legal enforceability. Both parties must fulfill reciprocal promises. Trick to remember: trick word, carp. C, offer, proposal. A, R, reciprocal promise. C, consideration. V, void agreement. V, void contract. V, voidable contract. This will help you recall all key definitions in order. Law of contract, simplified. It is the foundation of all business activities. Everyday actions, like buying groceries, taking a cab, or watching a movie, involve contracts. Contracts can be express, spoken, written, or implied, understood through actions. Examples of contracts in daily life. Buying a movie ticket. You pay for a ticket, and the theater allows you to watch the movie, giving clothes for dry cleaning. You expect clean clothes, and the shop expects payment. Buying milk and bread. You pay, and the seller gives you the product. ExpressCon 3. Why is the law of contract important? Ensures that promises made in business must be fulfilled. Prevents people from breaking agreements without consequences. Provides legal remedies if a contract is broken. What happens if someone breaks a contract? If a party does not fulfill their promise, the affected party can seek compensation, demand performance of the contract, take legal action. Key points to remember: contracts happen every day, often without us realizing it. Agreements can be express, spoken, written, or implied, understood from actions. Contracts ensure business runs smoothly by enforcing promises. Breaking a contract can lead to legal consequences. Trick to remember. Trick word. Contracts happen in daily life. 8. Agreements can be express or implied. Promises must be honored in business. This will help you recall the basics of contract law easily. Meaning and definition of a contract simplified. 1. What is a contract? The word contract comes from the Latin word contractum, meaning drawing together. Definition, Section 2H, a contract is an agreement that the law will enforce. In simple words, a contract is a set of promises between two or more people, which becomes legally binding when all conditions are met. 2. Definitions by experts. A contract is any agreement or promise that can be enforced by law. Salmond, a contract defines obligations, duties between parties. Sir William Anson, a contract is an agreement where one party gets rights and the other has duties. 3. Key elements of a contract. 1. Agreement, offer plus acceptance. One person makes an offer, e.g., I will sell my phone for $10,000. The other person accepts, e.g., I agree to buy it for $10,000. This makes an agreement. 2. Enforceability by law. The agreement must be legal and binding. If one party does not fulfill the promise, the other can go to court. Example, a contract to commit a crime is not valid. 4. Contract formula, easy to remember. Contract equals agreement enforceability by law. Agreement offers acceptance. Act 5, examples of contracts. Valid contract. Buying a car, you pay and the seller gives you the car, legally enforceable. Not a contract. A promise to meet a friend, no legal obligation, not enforceable. A deal to steal something, illegal, against public policy. Key points to remember. A contract is a legally binding agreement. An offer must be accepted to form an agreement. The agreement must be legal and enforceable. Illegal activities cannot be contracts. Trick to remember. Trick word. O. Offer. L. Law enforceability. A. Acceptance. This will help you recall contract basics easily. Essentials of a valid contract simplified. A valid contract is one that the law recognizes and enforces. If any required element is missing, the contract becomes invalid, void, or unenforceable. 1. Agreement, offer, acceptance. One party must make a lawful offer, and the other must give lawful acceptance. Example, a shopkeeper offers to sell a pen for 10, you accept. Now it's an agreement. Formula. Agreement, offer plus acceptance. 2. Intention to create legal relations. The agreement must be meant to create legal obligations. Example, a promise to meet a friend for dinner is not a contract because it's a social agreement. Rule, personal or social agreements are not contracts. 3. Lawful consideration, give and take. Consideration, something of value exchanged. Example, A sells a book to B for $200. A's promise to give the book equals consideration for B. B's promise to pay $200 equals consideration for A. Formula, consideration, give something plus get something. 4. Capacity of parties, who can enter a contract, must be 18 years or older, sound mind, not disqualified by law, e.g., an insolvent person cannot contract. Example, a minor under 18 buying a bike, contract is not valid. 5. Free and genuine consent. Consent must be free, no pressure, fraud, or mistake. If consent is taken by coercion, force, e.g., threatening someone with a gun, fraud, e.g., selling fake gold as real gold, misrepresentation, e.g., hiding defects in a product. Example, A threatens B to sign a contract, contract is voidable at B's option. 6. Lawful object. The purpose of the contract must be legal and moral. Example, a contract to smuggle goods is not valid because smuggling is illegal. A landlord renting a house to a criminal for illegal activities, contract is void. 7. Writing and registration. Some contracts must be in writing and registered. Example, sale of property must be in writing and registered. Gift agreements, love and affection, must be in writing. 8. Certainty of terms. The contract must be clear. Vague agreements are void. Example, I will sell my car for a reasonable price. Uncertain, not valid. I will sell my car for 5,000, certain and valid. 9. Possibility of performance. The contract must be possible to perform. Example, I will make you immortal, impossible, so void. I will supply 100 kilograms of mangoes, but all mango trees die due to disease. Contract is frustrated. Agreement must not be illegal or void. A contract must not be declared void or illegal by law. Example, contract to kill someone, illegal and void. Contract to stop someone from marrying, void. Short trick to remember. AICCFLWCPV, and in Canada can fry large white chicken pieces very well. Agreement, offer plus acceptance. I, intention to create legal relations. C, consideration, given tacity, 18 plus, sound mind. Free consent, no fraud, coercion. L, lawful object. W, writing and registration. Certainty of terms. Possibility of performance. Void, illegal agreements, not allowed. This trick will help you quickly recall the essentials of a valid contract. Agreement versus contract, simplified. Key rule, all contracts are agreements, but not all agreements are contracts. 1. What is an agreement? When two or more people agree on something, it is called an agreement. Example, A promises to sell his cycle to B for 1,000 and B agrees. Formula, agreement equals offer plus acceptance. 2. What is a contract? A contract is a legally enforceable agreement. An agreement becomes a contract when it fulfills certain conditions, as per Section 10 of the Indian Contract Act, 1872. Formula, contract equals agreement plus legal enforceability. Conditions for an agreement to become a contract. An agreement must satisfy these conditions to become a contract. 1. Consideration. There must be a benefit or price for the promise, give and take. 2. Competent parties. Both parties must be 18 plus, of sound mind, and not disqualified by law. 3. Free consent. No force, fraud, misrepresentation, or undue influence. 4. Lawful object. Purpose of the agreement must be legal. No smuggling, crime, etc. Example, A sells his bike to B for 50,000. This is a contract because it has all the conditions. A promises to give B 10,000 as a gift. This is just an agreement, not a contract. This is short trick to remember. CCFL, chocolate cake feels lovely. Consideration. Competent parties. Free consent. L, lawful object. This will help you quickly recall the difference between agreement and contract. Types of contracts. Simple explanation. A contract can be classified based on enforceability, whether it can be legally enforced or not. 1. Valid contract. A contract that fulfills all legal requirements, offer, acceptance, consideration, lawful object, etc. It can be enforced in court if broken. Example, X agrees to marry Y, and Y accepts. Valid contract. A buys a fridge from a store, pays for it, and the store delivers it. Valid contract. 2. Void contract. No legal effect. A contract that was valid when made, but later becomes invalid due to certain reasons. It cannot be enforced in court. Example, A and B agree to marry, but A goes mad before marriage. Contract becomes void. A agrees to transport goods to a foreign country, but war is declared. Contract becomes void. 3. Void agreement. Never valid. An agreement that was never valid from the beginning because it lacked one of the essentials of a contract. Even if one party suffers a loss, they cannot claim compensation. Example, an agreement to sell, void agreement. 4. Voidable contract. One-sided enforcement. A contract that can be enforced by one party but not by the other. Happens when consent is not free, coercion, fraud, undue influence, misrepresentation. The affected party can either continue or cancel the contract. Example, A forces B to sign a contract at gunpoint. B can cancel the contract because of coercion. 5. Illegal contract. Forbidden by law. A contract that is against the law, public policy, or morality. completely unenforceable and taints related contracts. Example, A, B, and C agree to divide profits from fraud, illegal contract. A hires B to commit a crime. Note, all illegal contracts are void, but not all void contracts are illegal. 6. Unenforceable contract. Technically defective. A contract that is legally valid but cannot be enforced due to a technical issue. It can become enforceable if the defect is corrected. Example, an insurance policy without proper stamp duty cannot be enforced in court until the stamp duty is paid. Short trick to remember. VVVVIU, very, very, very valuable, important understanding. V, valid contract. Void contract. V, void agreement. Voidable contract. Illegal contract. U, unenforceable contract. This will help you quickly recall the types of contracts in exams. Void versus voidable contracts. Simple explanation. Both terms sound similar, but they have key differences. Let's break it down. Definition. Void contract. A contract that cannot be enforced by law, invalid from the beginning or becomes invalid later. Voidable contract. A contract that can be enforced, but only if the aggrieved party wants, valid unless cancelled. Example, void. A contract to sell smuggled goods. Illegal, so always void. Voidable. A contract signed under fraud, valid unless the victim cancels it. 2. Nature. Void contract. Starts as valid but later becomes invalid due to reasons like impossibility, illegality, or violation of law. Voidable contract. Valid but has a defect like fraud, coercion, or undue influence, which gives one party the right to cancel it. Example. Void. A contract to build a house, but later a government ban is imposed on that land, becomes void. Voidable. A person forced to sign a contract at gunpoint. Can cancel it if they want. Rights of parties. Okay. No legal remedy, parties cannot enforce it. Voidable contract. The affected party can choose to continue or cancel it. Example, void a contract to sell drugs. No rights for anyone. Voidable, a fraudulently signed contract. The victim can continue or cancel. 4. Indemnity, compensation for loss. Void contract. No compensation because it was never legally valid. Voidable contract. The affected party can claim compensation for losses suffered. Example, void, a contract for illegal betting. No refund or claim possible. Voidable, a person tricked into buying fake gold can demand compensation. 5. Legal obligation. Void contract. No legal rights or duties for any party. The aggrieved party can either accept or cancel it. Example, void, a contract to kill someone, not legally binding. Voidable, a minor who bought a bike on EMI can refuse payment later. 6. Can it become valid again? Void contract. Cannot be changed into a valid contract. Voidable contract can become valid if the affected party chooses to continue it. Example, void, a contract that becomes illegal due to law change. Never valid again. Voidable, a contract made under pressure, but later the victim agrees to continue. Becomes valid. Trick to remember. VRL, very rare real intelligent legal logic. Validity. Void equals no, voidable equals yes, if victim agrees. R rights. Void equals no rights, voidable is aggrieved party has rights. Remedy. No voidable compensation possible. I indemnity. Void equals no indemnity, voidable is compensation given. Well, legal obligation. Void equals no obligation, voidable party can choose. Void legally enforceable. Void is not enforceable. Voidable is enforceable if not cancelled. Use VRL to recall key differences in exams. Void agreement versus illegal agreement, simple explanation. Both are unenforceable, but they have key differences. Let's break it down. 1. Basic definition. Void agreement. Not enforceable by law, but not always illegal. Illegal agreement. Forbidden by law and punishable. Example, void agreement, a contract with a minor. Not illegal, just not valid. Illegal agreement. A contract for selling drugs, illegal and punishable. Effect on collateral agreements, related transactions, void agreement. Other connected agreements remain valid. Illegal agreement. All related agreements also become illegal. Example: void agreement. A miner buys a house. The seller's loan contract with the bank remains valid. Illegal agreement. A contract to smuggle goods. Any related shipping contract also becomes illegal. 3 legal consequences. Void agreement. No punishment for parties. Illegal agreement. A parties can be punished for violating the law. Example: void agreement. A contract signed by a mentally unstable person, not valid but no punishment. Illegal agreement. A contract to bribe an official, punishable. Task 4. Refund of money. Void agreement. Money paid can be recovered. Illegal agreement. Money paid is lost. Example: void agreement. If a contract becomes void due to legal issues, the paid amount can be refunded. Illegal agreement. If money was paid for illegal betting, it cannot be recovered. Trick to remember. VICP, void is clean and punishable. Validity, both are not valid. Impact on collateral, void equal valid, illegal equals invalid. C, consequences, void equals no punishment, illegal equals punishable. Payment recovery, void equals refund possible, illegal equals no refund. Use VICP to recall key differences in exams. Void agreement versus void contract, simple explanation. Both are unenforceable, but there are key differences. 1. When do they become void? Void agreement. Invalid from the start, ab initio. Void contract. Valid at first, but later becomes void. Example: void agreement. A contract with a miner, invalid from the beginning. Void contract. A contract to supply goods, but later the government bans those goods. Initially valid, later void. Compensation. Void agreement. No compensation for loss. Void contract. Compensation may be available. Example: void agreement. If someone pays advance money in a contract with a miner, they cannot get it back. Void contract. If a supplier has already delivered goods under a contract that later became void, he may get compensation. 3. Ownership of goods. Void agreement. No legal rights over goods. Void contract. Ownership is valid before it becomes void. Example: void agreement. Buying land with a fake signature, no right to sell it. Void contract. Buying a machine legally, but later the contract is canceled. You can sell it before cancellation. Trick to remember. Wokes, when, ownership, compensation, when it becomes void, agreement from start, contract later. Ownership, agreement equals no rights, contract rights before void. C, compensation, agreement equals no refund, contract may get refund. Use WOC to recall key differences in exams. Types of contracts based on formation. Contracts can be formed in different ways. Let's break it down. 1. Express contract. Clearly stated agreement. Made by words, spoken or written. Offer plus acceptance equals express contract. Example: oral contract. I will sell my car for $1,000. I agree to buy it. Written contract. A signed agreement to sell a house. Implied contract. No words, just actions. Agreement is understood from behavior. Offer and acceptance happen through actions. Example: boarding a bus, schools promise to pay fare. Eating at a restaurant, promise to pay the bill. Quasi-contract. Obligation by law. Not a real contract. Created by law, not mutual agreement. Prevents unfair gain at someone else's loss. Example: a mistakenly paid extra electricity bill. The company must refund. A person finds your lost wallet and spends money, he must return it. Trick to remember. EIQ, express implied quasi. E, express. I implied, actions. Q, quasi, law imposes. Use EIQ to recall in exams. Types of contracts based on performance. Contracts can be categorized based on whether they are completed or pending. Let's break it down. 1. Executed contract. Completed contract. Both parties have fulfilled their promises. Nothing is pending. Example. A buys 100 cotton bales from B at $5,000 per bale. B delivers the cotton and A makes the payment. Contract is fully executed. One or both parties still have to fulfill obligations. Work is still in progress. Example. A buys a car from a dealer. A pays the money, but the ownership transfer is pending. Contract remains execute to remember. EE. Executed. E. Executed, everything done. Executory, everything pending. Use EE to recall in exams. Types of contracts based on obligation. Contracts can be one-sided or involve both parties. Let's understand. Unilateral contract, one-sided. Only one party has performed, the other still has to. Promise is one-sided. Example. A pays bus fare for a journey from Jaipur to Kota. The transport company still has to provide the service. A has done his part, now it's the company's turn. Bilateral contract. Both parties have to perform obligations. Promise is mutual. Example, A agrees to buy a laptop from B, A has to pay, and B has to deliver the laptop. Both parties have obligations. Trick to remember. UB, unilateral, bilateral. U, unilateral, one-sided. Bilateral. Use UB to recall easily in exams. Offer and acceptance. To form a contract, one person must offer and the other must accept it. Let's break it down. 1. Offer. One party expresses willingness to make a contract. Must be clear, definite, and legally valid. Example. R says to S, I will sell my machine for $9,000. Are you ready to buy? This is an offer from R to S. Key points. Must be communicated. The other person should know about it. Should be specific. Price, product, and terms must be clear. Not a mere invitation, like displaying items in a shop. This is not an offer. Trick to remember. Offer, acceptance, terms. Proposal to make a contract. A. Acceptance, agreement to the offer. T. Terms, clear and specific conditions. Use OAT to recall easily in exams. How an offer is made? An offer can be made in 2 ways. 1. Express a clearly stated offer. When an offer is made through words, spoken or written, or actions. Examples. By words, written or oral. A writes a letter to B. I will sell my house for 50 lakh. A calls B and says, I will sell my house for 50 lakh. Oral offer. By conduct, actions, or gestures. A waves a taxi to stop. This is an offer to hire the taxi. A raises his hand at an auction. This is an offer to buy the item. Important. Silence is not considered an offer. Nature 2. Implied offer. Indirect, when an offer is understood from actions or circumstances without being directly stated. Examples. By conduct. A runs a boat service from Mumbai to Goa. Just keeping the boat ready for passengers means he is offering a ride. No need for words. By omission, doing something. A tells B, I won't file a case against you if you pay 200s. A is making an offer by not filing a case. Trick to remember. EI, express, implied. Express, clear words or gestures. I, implied, understood from actions. Use EI to recall easily in exams. Essential elements of a valid offer. A valid offer must meet certain conditions to be legally acceptable. Let's simplify them. 1. Legal relationship. The offer must create legal obligations. Not a valid offer. Come for dinner at my place. This is a social invitation, not a legal contract. 2. Clarity and certainty. The offer should be clear and definite. Wrong. I will sell 100 quintals of oil. Which oil? Coconut? Mustard? Right. If A is a coconut oil dealer, it is understood. Express or implied. Can be spoken, written, or understood from actions. Express offer. I will sell my bike for 20,000. Implied offer, a taxi waiting at a stand offered to drive passengers. For offer versus invitation to offer. An offer can be accepted, but an invitation to offer is just an invitation for negotiation. Example, invitation to offer. A shopkeeper displays a product, the customer makes an offer to buy. Offer, the shopkeeper agrees to sell at a fixed price. Specific or general. Specific offer, made to a particular person, e.g. I offer my bike to you. General offer, open to anyone, e.g. reward 500 for returning my lost wallet. 6. Must be communicated. The offeree must know about the offer to accept it. If a catches a thief without knowing about a reward, he cannot claim it. 7. Consent of offeree. The offer must be made with the intention that the offeree will accept it. 8. Can be conditional. The offeror can set conditions for acceptance. Example, if you pay in cash, I'll sell the phone for $10,000. 9. No automatic acceptance. Silence is not acceptance. If you don't reply by Friday, I'll assume you accepted my offer. This is not valid. Trick to remember. LCEISCCCN. LECCN. L. Legal relationship. C. Clarity and certainty are implied. I. Invitation to offer, offer. Chess. Specific or general. C. Communicated. C. Consent of offeree. Can be conditional. N. No automatic acceptance. Use yen to recall easily in exams. Lapse of an offer, when an offer ends. An offer must be accepted before it ends. Here are the ways an offer can lapse. 1. Revocation, canceled before acceptance. The offeror can take back the offer before the offeree accepts it. Example, X offers to sell a car to Y by letter. Y accepts at 1 p.m. on Jan 7th. X can cancel the offer before 1 p.m., but not after. Lapse of time. If the offer has a time limit and is not accepted within that time, it ends. If no time is mentioned, it should be accepted within a reasonable time. Example, an offer made in June but accepted in November equals invalid. Too late. Death or insanity of either party. If the offeror, person making the offer, dies or becomes insane before acceptance, the offer ends. But if the offeree doesn't know about it and still accepts, the contract is valid. 4. Not fulfilling conditions. If an offer has conditions, they must be met for acceptance. Example, X offers to sell a car only if Y pays $20,000 advance. Y agrees but doesn't pay. The offer lapses. 5. Counteroffer. If the offeree makes a counteroffer, the original offer ends. Example, X, I will sell my car for $100,000. Y will buy it for $90,000. Counteroffer, rejection of $100,000 offer. Later, Y says, okay, I'll take it for $1,000. This is a new offer, not acceptance of the old one. 6. Wrong mode of acceptance. If the offer mentions a specific way of acceptance, it must be followed. Example, X says, accept by telegram. Y accepts by letter. X can reject the acceptance. 7. Rejection by offeree. If the offeree rejects the offer, it ends immediately. Once rejected, it cannot be accepted later. 8. Offer becomes illegal. If the subject of the offer becomes illegal before acceptance, it lapses. Example, X offers to sell 100 tons of sugar, but the government bans sugar sales. Offer ends. If the item is destroyed, the offer also ends. Example, X offers to sell his car, but it catches fire before Y accepts. Offer ends. Trick to remember, RTDD CMRI, revocation. T, time lapse. D, death or insanity. C, condition not met, mode of acceptance wrong. R, rejection by offeree. I, illegality or destruction. Use RTD-CMRI to recall quickly in exams. Acceptance, agreement to offer. What is acceptance? Acceptance means agreeing to the terms of an offer. When an offer is accepted, it becomes a promise leading to a contract. 1. Offer acceptance equals contract. A contract is formed when both parties agree on the same terms. Example, A, I will sell my car for $1,000. B, I agree to buy it for 1,000. Here, B's agreement is acceptance, forming a contract. Its acceptance must be clear and final. The offeree must fully accept the offer without any change. Example, X, I will sell my phone for 10,000. Y, I agree but will pay in installments. Not a clear acceptance, but a counteroffer. 3. Once accepted cannot be revoked. After acceptance, it cannot be taken back. Example, A offers to sell his bike to B. B agrees. Now B cannot say, I changed my mind. Real-life example, share market. Applying for shares equals offer. Company allots shares acceptance. Once allotted, the contract is complete. Trick to remember, OCA. O, offer is made. C, clear acceptance. A, agreement it was common to recall quickly in exams. Who can accept an offer? Basic rule, only the person to whom the offer is made can accept it. 1. Specific offer. Made to a particular person group, only they can accept the offer. Example, X sold his business to Y. Old customer Z placed an order to X, not knowing about Y. Y supplied the goods, but no contract was formed because Z never made an offer to Y. General offer. Made to everyone, public at large. Anyone who fulfills the terms can accept. Example, a company promised 100 reward to anyone who used its medicine and still got sick. Mrs. Aurora used it, got sick, and claimed the reward. Types of acceptance. Express acceptance, direct. Acceptance through words, spoken, written. Example, X, will you buy my car for 1,000? Yes, I will. Implied acceptance, acceptance through actions, conduct. Example, X boards a public bus. By sitting inside, he accepts to pay the fare. Trick to remember. SGEI, specific, general, express, implied. S, specific offer, limited people. G, general offer, anyone can accept. E, express acceptance, words. I, implied acceptance. Use SGE to recall easily in exams. Essentials of a valid acceptance. Basic rule. To form a valid contract, acceptance must follow certain rules. 1. Absolute and unconditional. Acceptance must be clear, no changes conditions. If conditions are added, it becomes a counteroffer, not acceptance. Example, X offers to sell his car for 1,000. Y replies, I accept, but only if you include free insurance. This is not acceptance, it is a counteroffer. Within proper time, must be accepted before the offer expires. If no time is given, it should be reasonable, decided by court if disputed. Example, X offers a job to Y and asks for a reply within 3 days. Y responds after 5 days. The offer has lapsed, must be communicated. Acceptance must be told to the offeror. Just deciding in mind does not count as acceptance. Example, X offers to sell a bike. Y mentally agrees but does not inform X. No contract is formed. #4 must follow prescribed mode. If the offerer asks for a specific way of accepting, it must be followed. If no mode is mentioned, it should be reasonable. Example, X says accept by email. Y sends a letter instead. X can reject the acceptance. Only the offeree can accept. Only the person to whom the offer is made can accept. No one else can accept on their behalf. Example, X offers a job to A. A's friend B accepts on A's behalf. No contract is formed. 6. Acceptance must follow offer. Offer comes first, then acceptance. If someone accepts before an offer is made, it is not valid. Example, Y tells X, I accept your offer to sell your bike. X has not made any offer yet. No contract exists. 7. Rejected offer cannot be accepted. If an offer is rejected, it cannot be revived later. A fresh offer must be made. Example, X offers to sell his phone for 10,000. Y rejects the offer. Later, Y changes his mind and says, I accept. No contract unless X makes a new offer. Trick to remember, ABC poor. Absolute and unconditional, within proper time. C, communicated to offerer. P, prescribed mode followed. O, only offeree can accept. A, acceptance must follow offer. R, rejected offer can't be accepted. Use AWC to recall easily in exams. Basic rule: no contract is valid without consideration, something in return. 1. What is consideration? Something in return for a promise. If one party promises to do something, the other must give something in return. Without consideration, the contract is not valid, except in some cases. Example: X agrees to sell his phone to Y for $10,000. X consideration: giving the phone. Y's consideration: paying $10,000. Result: a valid contract. 2 key points of consideration. At the desire of the promiser, must be done because the promiser wants it. Can move from anyone. A third person can also give consideration. Can be past, present, or future, given earlier, now, or promised for later. Need not be adequate. Amount doesn't have to be fair, but should be real. Example: A helps B without being asked. Not consideration. A helps B because B promised 500. Consideration exists. 3 types of consideration. Past consideration, given before the contract. Example: X helped Y last year. Y now promises 5,000 for that help. Present consideration, given at the time of the contract. Example: X sells his bike to Y and Y pays immediately. Future consideration, a promise to do something later. Example: X agrees to paint Y's house next month and Y will pay after completion. 4 important definitions. Pollock, price for which a promise is bought. Blackstone, recompense reward given for the contract. Cheshire and Feefoot, price paid by one party for the other's promise. Trick to remember: DMTPN, desire of promiser. M, move from anyone. T, types, past, present, price for promise. N, need not be adequate. Use DMTPN to recall easily in exams. Essentials of a valid consideration. Basic rule: a contract needs consideration, something in return, to be valid. 1. Consideration must be at the desire of the promiser. Must be done because the promiser requests it. Voluntary acts don't count as consideration. Example: A helps B during a fire without being asked. Later, A demands money. Not valid consideration. 2. Consideration can come from anyone. Not necessary that only the promisee gives consideration. A third party can provide it too. Example: X promises to pay 5,000 to Y if Z paints X's house. Z paints the house. Valid contract, though Z was not part of the promise. 3 can be past, present, or future. Consideration can be given earlier, at present, or promised later. Example: Past: A gave B 5,000 last year. Now B promises to return it. Present: A sells a laptop, and B pays immediately. Future: A agrees to deliver goods next month. B promises to pay then. 4 need not be equal in value. Consideration can be small or large. It just needs to exist. Courts don't check fairness, only whether something was given in return. X sells a 50,000 phone for 5,000. Still valid if both agree. Cannot be something the promiser is already bound to do. A new promise must add something extra. If it's a legal or contractual duty, it's not valid consideration. Example: A police officer demands a reward for catching a thief. Not valid. 6. Can be an act, abstinence, or promise. Forbearance to sue. Not suing someone in exchange for a promise. Compromise of dispute. Settling a claim is valid consideration. Composition with creditors. Debtors settling for less is binding. Example: A owes B 100 at 20% interest, but agrees to pay 25% if B doesn't sue. Valid. 7 must be real, not fake or impossible. It must be something practical and legal. Fake promises, magic, or illegal acts don't count. Example: A promises B gold from the sun for 10,000. Impossible, not valid. 8 must not be illegal or against public policy. If consideration is illegal, immoral, or harmful, the contract is void. Example: A pays B to smuggle goods. Illegal, not enforceable. Trick to remember, DMTANPRI. Desire of promiser. Move from anyone. Types, past, present, future. A, adequacy, not required. N, not already a duty. P, promise, forbearance, or act. Real, not fake. Illegal equals void use. DMTANPRI to recall easily in exams. Exceptions to no consideration, no contract. General rule. A contract must have consideration to be valid. Exceptions. Some agreements don't need consideration, but are still valid. Natural love and affection. Section 25(1). Agreement is valid without consideration if it's written, it's registered, it's based on love and affection between close relatives. Example, a husband promises $1,000 per month to his wife in a registered document. Valid. 2. Promise to compensate. Section 25(2). If someone helps voluntarily or does something the promiser was legally bound to do, the promise to compensate is valid. Example, X finds Y's wallet and returns it. Y later promises $500. Valid. X helps put out a fire in Y's house. Y later promises $1,000. 3. Paying a time-barred debt. Section 25(3). If a debt becomes too old to be legally claimed, but the debtor agrees in writing to pay, it is valid. Example, A borrowed $10,000 from B but never repaid. After the time limit expires, B promises to pay $5,000 in writing. Valid. 4. Completed gifts, explanation to Section 25. If a gift is given and accepted, no consideration is needed. Example, X gifts property to Y with a registered deed. 5. Agency contracts. Section 25. A promise to act as an agent does not require consideration. Example, A appoints B as his agent without any payment. Valid contract. Trick to remember, LCTGA. L. Love and affection. C. Compensation. T. Time-barred debt. G. Gifts. Agency. Use LCTGA to recall easily in exams. Trick to remember. Light. Love and affection. Indemnity. G. Gifts. H. History hisses. T. Trustee. Think of light. Contracts are valid even without consideration in these cases. Capacity to contract. Explain simply. What is capacity to contract? Only certain people can make a valid contract. If someone lacks legal capacity, the contract is not enforceable. Who can make a contract? Adults, 18 plus years old. Minors cannot make valid contracts. Sane persons, mentally unstable people cannot enter contracts. Not disqualified by law, people declared insolvent or enemy aliens cannot contract. Example, if a 15-year-old buys a bike on EMI, the seller cannot force him to pay because he lacks capacity to contract. Trick to remember. SAM. S. Sane mind. A. Adult. 18 plus. Not mad or legally disqualified. Think Sam. Only Sam can make a contract. Who can make a contract? Competency to contract, Section 11. Not everyone can make a valid contract. The law decides who is competent, eligible to enter into a contract. Who is not competent? Minors, below 18 years. A child cannot enter a contract. Mentally unsound persons. People with unstable minds cannot make valid contracts. Legally disqualified persons, insolvents, enemy aliens, etc., cannot contract. Example, if a 17-year-old signs a contract to buy a bike, the seller cannot enforce it in court. Trick to remember, MMS, below 18. Mental instability, status disqualified. Think MMS. These people cannot make a contract. Who is a minor? Section 3, Indian Majority Act, 1875. A minor is anyone below 18 years. But in some cases, the age limit is 21 years if a court-appointed guardian manages the minor's property. The Court of Wards is supervising the property. Example: a 17-year-old signing a contract to sell land is not valid. Even if the buyer pays, the minor can cancel the deal anytime. Trick to remember: M 1821-9 or below 18. 1821, if a guardian is involved, majority age is 20/1821. Termination of minority, Section 11, Indian Contract Act. How do we decide if someone is a minor? The law looks at two factors. One, for business deals, mercantile transactions, the law of the place where the contract is made applies. Two, for land property deals, the law of the place where the land is located applies. Example: a 17-year-old Indian, major in India at 18, signs a contract in Sri Lanka, where the majority age is 21. Since Sri Lanka's law applies, the person is still a minor there and the contract won't be valid. Trick to remember: L Pink mercantile business equals law of contract location. L and equals law of land location. P lace matters in determining majority. Think MLP. Mercantile equals contract place, land equals land place. Position of minors agreement, Indian Contract Act. What happens when a minor enters a contract? A minor, below 18 or 21 in some cases, cannot legally make a contract. Here's what you need to know. Key rules. 1. Contract with a minor is void. A minor cannot enter into a contract. Even if he/she borrows money or signs a document, it has no legal value. Example: a minor takes a loan and mortgages property. After becoming an adult, they can cancel the contract because it was void from the start. 2. Minor can be a beneficiary. A minor can receive benefits, like gifts, scholarships, insurance, etc. Example: a major person gives a promissory note to a minor. The minor can enforce it. No fraud claim against minor. If a minor lies about their age, they still cannot be held liable in a contract. Example: a minor misrepresents their age to buy a car. The seller cannot force payment. 4. No ratification on majority. A minor cannot fix an old contract after turning 18. Example: a minor signs a loan agreement. After turning 18, he cannot confirm it to make it valid. 5. Liability for necessities. If a minor gets food, education, or other essentials, the payment can be recovered from the minor's property, but the minor is not personally liable. Example: if a doctor treats a minor, he can claim the fees from minor's assets, but not force the minor to pay. 6. Minor as a partner. A minor cannot be a partner in a firm, but can receive profits if all partners agree. So minor as an agent. A minor can act as an agent, representing another person, but is not personally liable for mistakes. 8. Minor and insolvency. A minor cannot be declared bankrupt. Even if they owe money, only their property can be used to pay. 9. Contract by minor and adult jointly. If a minor plus an adult sign a contract together, only the adult is responsible. Minor's parents not liable. Parents are not responsible for a minor's contract unless the minor is acting on behalf of the parents. 1. Minor as a shareholder. A minor cannot buy shares unless the shares are fully paid. Trick to remember: blind partners. Beneficiary. L. Liability for necessities. I. Insolvency. N. No ratification. D. Debt. No liability. Parents not liable. Agent B, but not liable. R. Ratification. Third-party contract, minor plus adult equals only adult liable. N. No estoppel, cannot be forced to fulfill a contract. E. Enforceable by minor only if beneficial, registered shareholder only fully paid shares. Silent partner, minor can receive benefits. Think blind partners. A minor is blind in contracts but can still enjoy benefits as a partner. Persons of unsound mind, Indian Contract Act 1872. Who can make a contract? Only a person with a sound mind can enter into a valid contract. This means they must understand what they are doing and how it affects them. Key rules. 1. Person usually unsound, but temporarily sound equals can contract. If a mentally ill person sometimes has a clear mind, they can make a contract only during those clear moments. Example. A patient in a mental hospital can sign a contract if they are stable at that time. 2. Person usually sound but temporarily unsound cannot contract. If a normally sane person becomes mentally unstable for a short time, they cannot make a contract during that period. Example. A person with a high fever, extreme intoxication, drunkenness, or hypnotized cannot sign a contract. Types of mental incapacity: idiocy, permanent, born with no mental ability; lunacy, insanity, temporary, mental illness, but sometimes stable; drunkenness, temporary, alcohol, drugs block judgment; hypnotism, temporary, artificial sleep, no control over actions; mental decay, permanent, old age, memory loss, dementia, etc. Rule: if a person cannot understand what they are doing, the contract is void. Trick to remember: I love idiocy, born with it, never sound; L. lunacies, sometimes sane; O. old age, mental decay; V. void contract, all cases; E. effects of contract; D. drunkenness; temporary unsoundism; artificial sleep. A. agreements are void. Think, I love dehacked. If the mind is blocked, the contract is locked. Persons disqualified by law from making contracts. Not everyone can make a contract. Apart from minors and persons of unsound mind, some people are disqualified by law. Key categories of disqualified persons. 1. Alien enemies. A foreigner, alien friend, can make contracts in India only during peacetime. If war starts, they become an alien enemy and cannot enter into contracts. Example. A company from another country trading with India will have to stop business if war is declared. 2. Foreign sovereigns and ambassadors. They can make contracts, but enjoy a special privilege. They can sue others, but cannot be sued without government approval. Example. If a company enters a deal with an ambassador, they can be sued only if the central government allows it. 3. A person in jail cannot make contracts until their sentence ends. They also cannot sue while in jail, but can resume legal rights after release. Example. A businessman jailed for fraud cannot sign new business deals from prison. 4. Insolvents. A person declared insolvent, unable to pay debts, cannot sell their property because it belongs to the official receiver. They also cannot hold important positions, e.g., company director, magistrate. After clearing insolvency, they can act like a normal citizen. 5. Companies and corporations. A company is an artificial person and can only do what is written in its legal documents. It cannot enter into personal contracts, e.g. marriage. Example, Elik Life Insurance Corporation cannot sign a contract outside its business activities. Pardonation women. Women who live in seclusion and do not interact freely with society get special legal protection. A contract with them is assumed to be influenced or unfair unless proven otherwise. 7. Married women. A married woman can enter into contracts just like any other individual. Marriage does not take away her legal rights. Example. A married woman can own property and sue or be sued in her name. Trick to remember. Campfire, convicts, prisoners can't contract. A. Alien enemies, war equal no contracts. Mem. Married women can contract. P. Pardonation women need extra protection. F. Foreign sovereigns can't be sued easily. I. Insolvents, limited rights. R. Registered companies, limited to business scope. E. Think campfire. Some people are blocked from contracts just like fire blocks a path. Free consent, Section 13. For a valid contract, both parties must agree on the same thing in the same way. This is called consensus ad idem, Latin for same understanding. If there is confusion about the terms, the contract is invalid. Key points about consent. 1. Agreement on the same terms. Both parties must have the same understanding of the contract. Example, a painter agrees to paint a house for $2,000. The owner agrees. This is valid consent because both understand what is being agreed upon. 2. Mistaken identity or subject. If parties misunderstand the agreement, there is no consent. Example, X has 2 cars, Maruti and Fiat. X wants to sell the Fiat, but Y unknowingly offers to buy the Maruti. X accepts, thinking Y is buying the Fiat. No proper consent equals void agreement. Effect of no consent. If there is no proper consent, the agreement is void from the beginning, void ab initio. This means the contract never existed legally. C. Consensus ad idem. A. Agreement must be clear. M. Mistaken identity equal void contract. Think CAM like a car camera, which ensures clear vision. Just like contracts need clear agreement. For a contract to be valid, consent must be given freely without any pressure or deception. If consent is forced or influenced wrongly, the contract is not valid. Factors that affect free consent. 1. Coercion, Section 15. Forcing someone to agree using threats, violence, or unlawful pressure. A threatens to harm B's family if B doesn't sign the contract, not free consent. 2. Undue influence, Section 16. One party misuses their power or position to control the other party's decision. Example, a doctor forces a sick patient to sign property papers, not free consent. 3. Fraud, Section 17. Lying or hiding important facts to cheat the other party. Example, selling a car by falsely claiming it has a new engine. Not free consent. 4. Misrepresentation, Section 18. Giving false information by mistake without the intention to cheat. Example, a seller unknowingly says a phone has 128 gigabyte storage, but it has only 64 gigabytes. Not free consent. Mistake, Sections 20-22. When both parties misunderstand something important about the contract. Example, X agrees to buy a painting, thinking it's original, but it's a copy. Not free consent. Trick to remember. QFFMM. C. Coercion. U. Undue influence. Misuse of power. Fraud. Lying to cheat. M. Is misrepresentation. False info by mistake. Wrong understanding. Think UFMM, meaning law catches those who force others into contracts. Coercion, Section 15. Forceful consent. Coercion means forcing someone to agree to a contract by threatening harm to life, family, or property, doing something illegal as per the Indian Penal Code, withholding someone's property unfairly. Example, X tells Y, sell me your house for $5,000 or I will hurt your son. Y agrees out of fear. This is coercion. Key point. A contract made under coercion is voidable, i.e., the person forced can cancel it. The person forced can enforce it if beneficial, but the one who used coercion cannot. Effects of coercion, Sections 19, 64, 72. 1. Aggrieved party can cancel, Section 19. The person who was forced has the option to cancel the contract. 2. Restore benefits received, Section 64. If the victim cancels the contract, they must return any benefits received. 3. Other party must return money property, Section 72. If someone got money or goods by coercion, they must give it back. Trick to remember, core. Cancel option for aggrieved party, Section 19. Obligation to return benefits, Section 64. Repayment of money goods. Equals coercion reversed. Undue influence, Section 16. When power is misused. Undue influence happens when one person has power or control over another. That power is used to take unfair advantage. Examples. 1. Boss and employee. A boss forces an employee to sell property at a low price, or they'll lose their job. 2. Doctor and patient. A doctor convinces a sick patient to transfer assets in exchange for treatment. Guru and disciple. A religious leader convinces an elderly person to donate all their property for spiritual benefits. Key point. Contracts made under undue influence are voidable, can be cancelled by the weaker party. Sometimes the law assumes undue influence, like in guru-disciple cases. Coercion versus undue influence, the key differences. Fact coercion. Undue influence. Relationship, no need for prior relation. There is a relationship, boss-employee, doctor-patient, etc. Consent, given under threat, violence, or property loss, given under pressure, moral-emotional control. Pressure type, physical, fear-based. Mental, moral, trust-based. Who can use it? Even a stranger to the contract. Only a related party, boss, doctor, guru, etc. Returning benefits. Must return benefits, Section 64. May or may not return benefits, Section 19A. Legal presumption, not assumed, must be proven. Can be assumed in certain cases, guru, disciple, etc. Punishment can lead to criminal charges. Not criminal, but still unfair. Trick to remember. Tricked up. Coercion, compulsion, physical threat. Undue influence equal unfair. Using power, mental pressure. P, power relation exists in undue influence, but not in coercion. When power P is used unfairly, it's undue influence. Fraud, Section 17. When someone tricks you in a contract. Fraud happens when one party intentionally cheats another to make them sign a contract. 5 types of fraud, explained simply. 1. False statement. Lying about something important. Example, a seller claims a phone is brand new, but it's actually used. 2. Hiding important facts. Not telling something that should be disclosed. Example, a builder hides cracks in a house and sells it. 3. False promise. Making a promise with no intention to keep it. Example, a company promises a job after training but never hires anyone. 4. Trickery and deception. Any act meant to fool someone. Example, a lottery scheme tricks people into paying fees for fake prizes. 5. Legal obligation to disclose. Some laws require full disclosure. Example, a seller must inform if property is mortgaged before selling it. Caveat emptor, buyer beware. In normal sales, the buyer must check the product before buying, but if the seller hides a defect, it becomes fraud. Trick to remember, flipped, false statement. L, legal duty ignored, hiding important details. I, intention to cheat, fake promises. P, truth hidden, concealment. Think flipped, fraud flips the truth. Misrepresentation, Section 18, false but innocent statement. Misrepresentation happens when one party unknowingly gives false information or hides important facts, making the other party enter a contract. Unlike fraud, there is no intention to cheat. 3 types of misrepresentation explained simply. 1. False statement, but believed to be true. A person says something wrong, but thinks it's correct. Example, a seller says a phone's battery lasts 12 hours, but it actually lasts 8 hours. They didn't lie intentionally. 2. Breach of duty. Without intent to cheat, a person fails to do their duty and benefits unfairly. Example, an insurance agent forgets to mention a hidden clause that reduces coverage, benefiting the company. Causing mistaken agreement without realizing. Someone accidentally confuses another person about an important detail. Example, a jeweler sells a gold-plated ring, believing it is pure gold. The buyer is misled, but the jeweler didn't intend to cheat. Difference between fraud and misrepresentation. Fraud, misrepresentation. Intention, deliberate cheating. Innocent mistake. Contract is voidable and guilty party can be sued. Contract is voidable but no punishment. Example, selling fake branded shoes as originals. Selling a watch as waterproof without knowing it isn't. Trick to remember. FBC. F. False statement believed true. B. Breach of duty. C. Causing mistake in agreement. Think FBC false but clean mistake. Mistake. Section 20, 21, 22. Wrong belief about a fact or law. A mistake happens when one or both parties have a wrong belief about something in a contract. This can make the contract void or valid, depending on the type of mistake. Types of mistake and their effects. 1. Mistake of law. Not knowing the law. Indian law. If someone doesn't know the Indian law, they cannot cancel the contract. Ignorance of law is no excuse. Example, a buys land thinking tax is not required, but later finds out it's compulsory. The contract is valid. Foreign law. If someone doesn't know foreign law, the contract can be canceled because foreign laws are not easy to know. Example, A sells goods to B, but later realizes exporting them to another country is illegal. The contract is void. Mistake of fact. Wrong understanding in the contract. Bilateral mistake. Both parties confused. Contract is example. A agrees to sell a horse, but both A and B later realize the horse died before the deal. Unilateral mistake. Only one party is confused. Contract is valid unless the mistake was caused by fraud or misrepresentation. Example. A wants to buy a car model 2023, but mistakenly writes 2022. The contract cannot be canceled. Trick to remember. B. Bilateral mistake, both parties confused. L. Law mistake, Indian and foreign law. U. Unilateral mistake, only one party mistaken. Think big legal uncertainty. Mistake of law, section 21. Wrong understanding of legal rules. A mistake of law happens when a person misunderstands legal rules while making a contract. This can be of two types. Types of mistake of law and their effects. 1. Mistake of Indian law. Everyone is expected to know the laws of their own country. If you make a mistake about Indian law, you cannot cancel the contract. Example. A sells land to B, thinking that land tax is not applicable. Later, A realizes tax is required. The contract is valid because not knowing the law is not an excuse. 2. Mistake of foreign law. Can be excused. People cannot be expected to know the laws of another country. If both parties misunderstand a foreign law, the contract is void. Bilateral mistake. Example, A, from India, signs a contract with B, from the USA, thinking that a particular business is legal in the USA. Later, both realize it's illegal. The contract is void because both were mistaken. Trick to remember. If I, Indian law, ignorance is no excuse. F, foreign law, forgivable mistake. Think if. If it's Indian law, no excuse. If it's foreign law, can be excused. Mistake of fact, section 20 and 22, wrong understanding of reality. A mistake of fact happens when one or both parties misunderstand something important about the contract. This can be of two types. Types of mistake of fact and their effects. 1. Bilateral mistake. Both parties confused, contract is void. Both parties misunderstand the agreement. There is no proper offer and acceptance because both have different understandings. Example, A agrees to sell a car to B. A thinks he is selling a BMW, but B thinks he is buying a Mercedes. Since both misunderstood, the contract is void. 2. Unilateral mistake. One-sided mistake. Contract is valid. Only one party is mistaken. The contract remains valid unless the mistake is due to fraud or misrepresentation. Example, A mistakenly thinks he is buying a gold ring, but it is silver. If B didn't deceive A, the contract is still valid. But if B lied about it being gold, A can cancel the contract. Voidable. Trick to remember. B, bilateral, both mistaken, void. U, unilateral, one mistaken, valid. Both mistaken, no contract. Unilateral mistake, contract stays. Legality of object. The purpose must be legal. What is object in a contract? Object means the purpose of the contract, why it is being made. A contract must have a legal object or it becomes invalid. Key concept, object versus consideration. Considerations, what one party gives or promises, like money, goods, services. Object, the purpose behind the contract. Even if consideration is legal, the contract can still be void if the object is illegal. Example, A sells goods to B. B, who is bankrupt, assigns the contract to C for hundreds to avoid paying his creditors. Here, 100, consideration, equals legal. Defrauding creditors, object equals illegal. Since the object is unlawful, the contract is void. Trick to remember. OC. Object equals purpose of contract. C, consideration, what is given in return. Think OC, object matters more than consideration. When is consideration or object unlawful? A contract must have a lawful object and consideration. If not, the contract is void, not legally valid. 5 cases when a contract is unlawful. 1, forbidden by law. If the agreement involves doing something that is illegal, it is void. Example, A agrees to drop a robbery case against B in exchange for money. Not allowed. 2, defeats the law. If an agreement goes against the purpose of any law, it is void. Example, if a defaulter is legally banned from buying property, but makes someone else buy it for them, the agreement is invalid. 3, fraudulent. If the agreement is made to cheat or deceive others, it is void. Example, A, B, and C agree to divide stolen money among themselves. Illegal. 4, injury to person or property. If an agreement harms a person or their property, it is void. Example, X borrows 100 from Y and signs a bond forcing him to work unpaid for 2 years. This is unfair and illegal. 5, immoral or against public policy. If an agreement goes against morals or society's values, it is void. Example, A agrees to take money from C to influence B's decision unfairly. Trick to remember. FDFII. Sounds like Fifi. Forbidden by law. D, defeats the law. Fraudulent. I, injury to person or property. Immoral or against public policy. Just remember, Fifi. If a contract violates Fifi, it's void. Agreements declared void. A void agreement is an agreement that has no legal value from the beginning. It does not create any rights or obligations. When is an agreement void? Unlawful object or consideration. If the purpose or payment of a contract is illegal, the contract is void. Example, a contract with B to sell smuggled goods. Illegal. 2, agreement with a minor. A contract made with a minor below 18 years is void. Example, a 17-year-old buys a car on loan. The contract is not valid. 3, agreement without consideration. If a contract is made without any exchange of value, it is void. Example, a promise is to give B $10,000 without anything in return. Not a contract. 4, agreement against public policy. If an agreement harms society or public interest, it is void. So example, A agrees to pay B to spread false news about a political party. Trick to remember, UMWP. Sounds like UMP. U, unlawful object. M, minor's agreement. Without consideration. Public policy. Like an umpire who declares things invalid in cricket. If a contract violates UMP, it is void. Expressly declared void agreements. Some agreements are clearly stated as void under the Indian Contract Act. They have no legal value and cannot be enforced in court. Types of void. 4 to 30. 1. Unlawful consideration or object, partly illegal. Sec 24. If an agreement has both legal and illegal parts, and they cannot be separated, the whole agreement is void. Example, A works for B in legal farming and illegal smuggling for $90,000 per year. The contract is void because of illegal work. 2. Agreement without consideration, Sec 25. A contract without consideration, something in return, is void, except in cases like gifts, written promises, or compensation. Example, A promise is to give $50,000 to B without reason. The contract is void unless it is a registered gift deed. 3. Restraint of marriage, Sec 26. No one can be forced not to marry, except minors. Example, Preeti promises not to marry Kurup. 4. Restraint of trade. No one can be stopped from doing business or working in their profession. Example, A signs a contract never to open a bakery after leaving B's bakery. Void. Exceptions. Sale of goodwill, business partnerships, service contracts, reasonable restrictions. 5. Restraint of legal proceedings. No contract can stop someone from going to court for legal rights. Example, a contract says, "You cannot sue me." 6. Uncertain agreements. If an agreement is too vague or unclear, it is void. A agrees to sell some amount of land to B. Void. 7. Wagering betting agreements. Betting and gambling contracts are void in India. Example, X bets 1,000 with Y on rain tomorrow. Exception, horse racing under specific conditions. Trick to remember. URRUW sounds like you are win, but contracts are void. U, unlawful consideration partly illegal. Restraint of marriage. Restraint of legal action. U, uncertain meaning. Without consideration. Wagering agreements. Just remember, URDAR-UW. Contracts that break these rules are void. Unlawful versus illegal agreements. Some agreements cannot be enforced by law. However, there is a difference between unlawful and illegal agreements. 1. Difference between unlawful and illegal agreements. Unlawful agreement, illegal agreement. Not enforceable by law. Not enforceable affects others too. No further consequences. Any related transactions also become illegal. Example, a minor signs a contract to buy a house. It is void but not illegal. Example, B borrows money from L to buy smuggled goods. The main deal, smuggling, is illegal, so B's loan agreement with L is also illegal. 2. Effects of illegal agreements. Key rule, if an agreement is illegal, the law helps no one. Legal maxims, Latin rules that apply. 1. Ex turpi causa non oritur actio. No legal action comes from an illegal act. Example, A hires B to steal. Later, A refuses to pay. B cannot sue A. 2. In peri delicto, potior est conditio defendentis. If both parties are guilty, the law helps neither. Example, Ram offers Rahim 5,000 to beat Tita. If Rahim does it, he can't demand payment. If Rahim doesn't do it, Ram can't get his money back. Act 3. Effects of illegality, no legal protection. If an agreement is illegal, then no one can claim money property under it. No one can sue for breaking the agreement. If part of an agreement is illegal, then if legal and illegal parts are inseparable, the whole contract is illegal. If they can be separated, the court enforces only the legal part. Trick to remember, ULIE sounds like ill but illegal. Unlawful versus illegal. Law helps no one in illegal deals. I, illegal equals affects all related transactions. E, affects no money back, no legal action, partial contracts may work. Just remember, ULIE, illegal agreements are useless. Performance of contract, Section 2. What is performance of a contract? It means fulfilling the promises made in a contract by both parties. Promisor, the one who makes a promise. Promisee, the one to whom the promise is made. Key rule, both must perform their part of the contract unless excused by law. Example, A agrees to deliver 100 bags of rice to B for 50,000. If A delivers and B pays, the contract is fully performed. If A refuses to deliver, it is breach of contract. Contract ends when both parties complete their promises. Nothing more remains to be done. This is the natural way to complete a contract. Trick to remember, performance of promise. P, parties must perform their promises. O, obligations must be fulfilled unless excused by law. Performance leads to the contract's end. Just remember when fully performed. Types of performance of contract. A contract is considered performed in two situations. 1. Actual performance, meaning when a party fully completes what they promised in the contract. Example, A agrees to build a house for B, completes the house as per the contract. Contract is fully performed. Nothing is left to do. 2. Offer to perform tender, meaning when a promiser tries to fulfill the contract, but the promisee refuses to accept the performance. Example, A owes 10,000 to B. A offers to pay, but B refuses. A is not at fault. Interest on the amount stops running, but the debt remains. Key points about tender. The promiser is free from obligation. He keeps his legal rights under the contract. It is not considered non-performance. Trick to remember. At, actual and tender. Actual performance fully done, refused but legally valid. Just remember, think of AT the end of a contract. It's either done or offered but refused. Who can perform a contract? A contract can be performed by different people based on the situation. Promiser himself, meaning, if the contract is personal in nature, the promisor must perform it himself. Example, X promises to paint a picture for Y. Since painting is a personal skill, only X must do it. No one else can do it for him. Use when personal skill or trust is needed. Meaning, if the contract does not require personal skills, the promiser can hire someone, agent, to do it. Example, A hires a driver to deliver a car instead of doing it himself. Since any competent person can do it, an agent can perform. Use when personal involvement is not necessary. 3. Legal representatives. Meaning, if the promiser dies, the contract passes to their legal heirs, unless it required personal skill. Example, a promise to sell land to B. If A dies, his legal heirs must complete the contract. A promise to paint a picture. If A dies, the contract ends. Legal heirs perform unless personal skill is needed. 4. Third person. Meaning, if the promisee accepts performance from a third person, the promiser is free from duty. Example, A owes B 5,000. C pays on A's behalf. If B accepts the payment from C, A is free from debt. If the promisee accepts performance from someone else, the promiser is free. 5. Joint promisers. Meaning, when two or more people make a promise together, all must perform it jointly. Example, A, B, and C promise to pay 30,000 to D. If IB dies, his legal heirs plus A and C must still pay the amount. Joint promises, joint responsibility. Trick to remember, Part J. P, promiser himself, personal skill required. A, agent, any competent person can do it. L, legal representatives, if promiser dies, heirs perform. T, third person, if accepted, promiser is free. J, joint promisers, all must perform together. Think of Part J. To remember, who can demand performance of a contract? When a contract is made, someone must ensure it is fulfilled. These are the people who can demand performance. 1. Promisee, the main person. Meaning, the promisee is the person who was given the promise in the contract. They are the main person who can ask for performance. Example, A sells a bike to B. B, promisee, can demand A to deliver the bike. The person who received the promise can demand it. Agent, legal representative of the promisee, meaning the agent acts on behalf of the promisee and can demand performance. Example, A promises to deliver goods to B. B's agent can ask A to deliver the goods. The agent works for the promisee and has the same rights. 3. Legal representative, if promisee dies, meaning if the promisee dies, their legal heirs can demand contract performance. Example, A agrees to sell land to B. Before the sale, B dies. B's son, legal heir, can demand the land. Heirs can demand performance unless the contract was personal. 4. Third-person special cases, meaning usually a stranger to the contract cannot demand performance unless there is an exception. A takes an insurance policy for B. B can claim money from the insurance company. A third person can demand performance in special cases. Trick to remember, PALT, promisee, main person who can demand. A, agent, works for promisee. L, legal representative, if promisee dies. T, third person, only in exceptions. Think of PALT like bolt, but with a P to remember. Discharge of contract, end of contractual relationship, meaning a contract is discharged when it ends and no further obligations exist between the parties. Think of it as contract over, no more duties. Examples for better understanding. 1. A hires B to build a house. B completes the work. The contract is discharged. 2. X agrees to deliver 100 bags of rice to Y. X delivers, Y pays, contract ends. Once all duties are fulfilled or legally ended, the contract is discharged. Trick to remember. Done. D. Discharge means end of contract. O. Obligations are over. N. No more duties. E. Ends the relationship. Think of done to remember. Contract is done. Modes of discharge of a contract, meaning a contract can end, discharge, in different ways. One of the most common ways is performance, when both parties complete their duties as agreed. Example, A hires B to paint his house. B completes the painting. A makes the payment. Contract is discharged by performance. Think of it like finishing a job successfully. Just remember performance. Obligations fulfilled. Parties complete duties. Just remember pop. When a contract pops, it ends. Discharge of contract by mutual agreement, meaning a contract can end if both parties agree to cancel or change it. This is called discharge by mutual agreement and can happen in different ways. Types of discharge by agreement. 1. Novation, new contract. A new contract replaces the old one with consent. Example, A owes 100 to B and B owes the 100 to C. They all agree that A will pay C directly, discharging the old contract. 2. Alterations. Parties change the contract terms without changing the people involved. Example, A agrees to deliver 100 TVs to B by October, but both agree to extend it to November. 3. Rescission, cancel contract. A contract is canceled by mutual agreement or due to fraud, coercion, or breach. Example, if A and B mutually cancel a deal, they return the benefits received. 4. Remission, accept less amount. One party agrees to accept less than what was originally owed. Example, A owes B $5,000, but B accepts $2,000 as full payment. 5. Waiver, give up rights. A party voluntarily gives up its rights under the contract. Example, A is supposed to deliver goods to Y, but Y releases F from the obligation. Trick to remember, narrow N, novation. A, R, rescission, remission. O, obligation waived. Just remember, narrow, contracts become narrow, N when changed or canceled. Discharge of contract by impossibility, meaning A contract ends when it becomes impossible to perform. The law does not force people to do something that cannot be done. Types of impossibility. 1. Initial impossibility, before contract. The contract was impossible from the beginning, but still made. Example: a promises B to bring a dead man back to life, clearly impossible. Contract is void from the start. 3 scenarios. Known to both parties. Both knew it was impossible, e.g., dead man case. Unknown to both parties. They thought it was possible, but it was not, e.g., selling goods that were already destroyed in a shipwreck. Known to one party only. If the promiser knew it was impossible but still promised, he must pay for losses, e.g., a promises to marry B but is already married to C. 2. Supervening impossibility, after contract. The contract was possible at first but later became impossible. 5 cases where contract ends. 1. Destruction of subject matter. If the main thing needed for the contract is destroyed, the contract ends. Example: a music hall was rented for concerts but burned down before the event. Contract is void. 2. Death or incapacity. If a contract requires a personal skill, it ends if the person dies or becomes ill. Example: a singer agrees to perform but gets very sick. Contract is discharged. 3. War declaration. If a contract is affected by war, it may become void for national safety. Example: A agrees to transport goods to a foreign country. Later, war is declared with that country. Contract is void. 4. Change of law. If a new law makes the contract illegal, it is cancelled. Example: A agrees to sell land to B, but later the government takes the land. Contract is discharged. 5. Non-existence of essential condition. If the contract was based on a certain condition, and that condition no longer exists, the contract is void. Example: A and B agree to marry, but A becomes mentally ill before the wedding. Contract is void. Trick to remember: D. Wild. D. Destruction of subject matter. W. War declaration. I. Incapacity or death. L. Law changes. D. Disappearance of essential condition. Just remember D. Wild: when something wild, unexpected happens, the contract is discharged. Discharge of contract by lapse of time. Meaning, every contract has a time limit to be performed. If not completed within that time, the contract automatically ends, gets discharged. Key points. 1. Time limit exists. A contract must be completed within a fixed time, as per the law. 2. If time expires, contract ends. If not done in time, the contract cannot be enforced later. 3. Law decides the time limit. Different contracts have different time limits. Example 1. Debt recovery. If A has to recover money from B, he must do it within 3 years. After that, B can refuse to pay, and the law won't help A. Example 2. Property recovery. If A wants to reclaim his lost land, he must do it within 12 years. After that, the claim becomes invalid. Trick to remember: late. Lapse of time, automatic end of contract. T. Time limit decided by law. E. Enforcement not possible after expiry. Just remember, late. If you're late, the contract is gone. Discharge of contract by operation of law. Meaning, a contract automatically ends, gets discharged due to legal reasons. No action is needed from the parties involved. Key points. 1. Death. If a contract requires personal skill, like a singer or artist, it ends if the person dies. Example: a singer agrees to perform at an event but dies before the event. The contract is discharged. 2. Merger. If a smaller right merges into a bigger right, the smaller one disappears. Example: a tenant buys the property he was renting. His rental contract ends as he is now the owner. 3. Insolvency. If a person is legally declared bankrupt, they are freed from old contract obligations. Example: a businessman declares bankruptcy. He no longer needs to pay past debts. 4. Unauthorized alteration. If one person changes the contract terms without the other's consent, the contract ends. Example: A and B signed a contract. Later, A secretly changes the amount in the contract. The contract becomes invalid. 5. Same person. If the promisor and promisee become the same person, the contract ends. Example, A owes B money, but later B inherits A's property. Since B is now both the lender and borrower, the contract discharges. Trick to remember, death. M, insolvency. U, unauthorized alteration. Same person change. Just remember, Demas, if these happen, the contract is gone. Discharge of contract by breach. Meaning, a contract ends when one party fails to fulfill their promise. The other party, who is not at fault, can take legal action or claim compensation. 1. Breach equals failure to perform a promise. 2. The innocent party, aggrieved party, can take action. The contract is no longer valid after the breach. Example, A agrees to deliver 100 chairs to B by Monday. A does not deliver the chairs. B can cancel the contract or ask for compensation. Trick to remember, beef, if failure to perform. A, aggrieved party can take action. I, invalid contract after breach. L, legal consequences. Just remember, fail. If someone fails, the contract is gone. Breach of contract, meaning, what is breach of contract? When one party does not follow the contract or refuses to perform their promise, the contract is broken, breached. Key points. 1. Failure to perform a promise. 2. Informing the other party about non-performance. 3. Actions show that performance is impossible. Example, A agrees to paint B's house by Friday. On Wednesday, A tells B that he won't do it. This is a breach of contract because A refused before the deadline. Trick to remember. F, failure to perform. I, informing about non-performance. A, actions showing non-performance. Just remember, FEA. If someone fails, informs, or acts against the contract, it's a breach. Types of breach of contract. A contract can be broken in 2 ways. 1. Anticipatory breach, before due date. Happens before the due date of performance. The party informs or shows by actions that they won't fulfill the contract. 2 types. Expressly, spoken or written, a party directly says they won't perform. Example, X agrees to sell wheat to Y on 20th Oct, but informs on 1st Oct that he won't supply it. Impliedly, through actions, a party does something that makes performance impossible. Example, X agrees to sell wheat to Y on 20th Oct, but sells it all to Z on 1st Oct. 2. Actual breach on due date or during performance. Happens on the due date or while performing the contract. 2 types. On due date. A party refuses to perform when the time comes. Example, X agrees to deliver wheat to Y on the 20th Oct, but refuses on that day. During performance, a party starts the work but doesn't complete it. Example, X agrees to deliver 10 tons of wheat in 2 installments but delivers only 5 and refuses the rest. Trick to remember. ADA, anticipatory, before due date. I, implied breach, through actions. Due date breach, on time but refused. A, actual breach during performance. Just remember ADA. Anticipatory and actual breaches include implied and due date breaches. Remedies for breach of contract. When a contract is broken, breached, the aggrieved party, the one not at fault, has legal rights to get justice. These rights are called remedies. Rescission of contract. The contract is canceled due to the breach. The aggrieved party is freed from obligations. Example, A agrees to deliver 100 rice bags to B, and B agrees to pay on delivery. If A fails to deliver, B doesn't have to pay. Suit upon quantum meruit means as much as earned, payment is made for the work already done. Happens when a contract is partially completed before the breach. Example, a painter was hired to paint a house for $50,000. He painted half before the owner canceled the contract. He can demand payment for the work done. Suit for specific performance. The court orders the party to fulfill the contract, used when money is not enough as compensation. Example, A agrees to sell a rare painting to B but later refuses. The court can force A to deliver the painting. 4. Suit for injunction. The court stops a party from doing something they promised not to do. Used when the breach involves a negative term. Example, an actor signs a contract to work only with a studio, but starts working for another. The court can stop them from working elsewhere. 5. Suit for damages. The defaulting party pays money for the loss suffered. Most common remedy in breach cases. Example, a wedding photographer cancels at the last minute. The couple hires a new one at a higher price. The photographer must pay the extra cost. Trick to remember, QR-SID, quantum meruit, partial work payment. R, rescission, cancel the contract. Specific performance, do the job. Injunction, stop doing something. D, damages, pay money for loss. Just remember QR-SID, like a robot that enforces contract remedies. Chas 511. 5.11.1 Short answer type questions. 1. Give an introduction to the Indian Contract Act 1872. Discuss its application. 2. Discuss the essential elements of a valid contract. 3. How is an offer made? 4. Write a note on persons disqualified by law and persons of unsound mind. 5. What is fraud and misrepresentation? 6. Describe the types of breach of contract. Discuss the modes of termination of a contract. 8. Who may demand performance? 9. Who may perform a contract? 5.11 by 2 Long answer type questions. 1. Discuss the concept of agreement and contract. Explain different types of expressly declared void agreements. 2. Describe the essentials of a valid offer. Also enumerate the lapse of an offer. 3. Define acceptance. Explain the essentials of a valid offer. 4. No consideration, no contract. Explain and describe its exceptions. 5. All contracts are agreements, but all agreements are not contracts. Discuss in the light of the classification of a contract. 6. Who can make a valid contract? Discuss the position of minor agreements. 7. Discuss the concept of consent and undue influence. 8. What do you mean by the performance of a contract? Discuss the types of performance of a contract. 9. What are the remedies available to an aggrieved person in case of breach of a contract? Explain.